Hello, everyone. We're just going to wait a few minutes for more folks to trickle in before we get started. Hi, everyone. If you're joining us, we're just going to give it a few more minutes for others to trickle in. So if you're just joining us, we're just giving it a few more minutes for others to trickle in. Kim has put up a attendance poll. Um, if you are able to fill it out, please take the time to do so now. Okay, it looks like we have a pretty steady number of people. I'm sure others will join us. This will be recorded, then the slides will be shared so people can go back and watch whatever they have missed, or if they want to re listen to something, you can do that as well. My name is Patar Japay. I am the Charter School Initiative Attorney here at Advocates for Children. And today we are going to talk about promotions, special education, and students with disabilities, as well as discipline as it relates to charter schools. Kim, may you go to the next slide, please? Okay. There we go. Okay, so a little bit about Advocates for Children. Advocates for Children, or AFC, as we often refer to ourselves, is an independent agency that protects the rights of all New York City students. Our contact information is currently on the screen. We started in 1971. As a result of parents of students with disabilities getting together, we have grown tremendously over the years. We have a number of different project areas that people work on here, such as early childhood, charter schools, um, uh, New York State teaches or students that or individuals that work with unhoused populations, immigrant students, NLs, school justice, child welfare involved families, overage and undercredited students, and most recently, bullying, particularly around the areas of LGBTQ plus students. We have a helpline where individuals should feel free to call for assistance and also, if needed, represent families as well. Kim, next slide, please. Okay, so I just wanted to give an overview of what I hope to accomplish today, a roadmap, if you will. As I mentioned before, we will talk a little bit about academics in charter schools, so promotion criteria in charter schools, special education and students with disabilities in charter schools, and then also discipline and suspension expulsions in charter schools. Next slide. So bear with me. I hope to be a little interactive here. I wanted to have a polling question to kick us off. And the question says, what percentage of New York City public school students attend charter schools? What do you think? Is it 5%, 8%, 10%, 13%, or 15%? Feel free to add your answers in the chat box. Okay, I see an 8% in the chat box. Any other guesses? 13%, okay. 15%. All right, so our answer is indeed 15%. 15% of students attend charter schools in New York City. About 18.8% of those students have IEPs, and about 90% of those students identify as Black or Latinx. That's compared to about 64% of students in DOE or New York City public schools who identify as Black or Latinx. Next slide, please. So we talked a little bit about the populations that attend charter schools to give us some ground, some equal grounding footing. And I wanted to just go over general facts about charter schools, even though we have some key areas we want to focus on, just to give some general background facts about charter schools. So we broke this down into two categories: admissions policies. When it comes to admissions, charter schools cannot require tests or interviews. They can have grade or age requirements, right? So if it's a middle school, a high school, they can have requirements around that. And they can have some admissions preferences, such as sibling preference. So the older sibling attends the school, or they pull from a certain district, etc. Right? It's important to note that charter schools are public schools. And so admission is done by lottery. And they can't reject students with disabilities or even ask for an IEP prior to the admissions process. And they can't reject students who are English language learners. So those are the basic facts about charter schools and the admissions process. Next slide, please. So we're going to talk a little bit about academics in charter schools and promotion policies for students. Next slide, please. So one of the things that makes charter schools unique or different than district schools or DOE schools is that each charter school can set its own promotion or academic policies. So when a student or a family is entering a charter school or looking at a charter school, ask about these things. Um, so some of the things that may be different or that are are commonly seen as differences in charter schools, they excuse me, may have different attendance policies. They may have a minimum requirement for attendance or a higher grade passage rate. Often we see 70 and above rather than 65 as a passing score for subjects, for subject areas. Um, Charter schools often have a higher reliance on testing and standardized testing as their metric. And they often then don't have summer schools for students who may be struggling as a chance to catch up and be promoted to the next grade that you might see in a district school. They also tend to have a higher rate of repeating a grade or retention. Um, and also, one of the things that are common that we see a lot is mid-year demotions, and we'll talk about that in more detail and what is proper and what isn't. But those are some of the things that stand out and that families should really be asking prior to enrolling, especially if your child has any particular challenges that you can anticipate in any of these areas. Okay, next slide, please. So this is another polling question. This one is true or false. Is it true or false that charter schools must provide the services on a student's IEP? What do we think? Yes, no. Again, feel free to enter your answers in the chat box. I see yes, yes, true, true. So yes, true. True is the correct answer. Charter schools are responsible for carrying out the program and services on a student's IEP and providing specially designed instruction. So keeping that in mind, we go to the next slide. We'll talk a little bit about the IEP process for students in charter schools. So, students with disabilities in charter schools who need an individualized education program, often referred to as an IEP, follow the same process as students in district schools. The picture on the screen goes through the process: referral, consent, evaluation, IEP development, and then placement and services. So I'm not going to go into great detail about that, but I do want to point out some of the differences, right? So for students who have IEPs, um, the and who are in charter schools, the charter school themselves can refer students directly for IEP services, or the DOE can do that. And the mechanism for that is through the CSC, where the charter school is located. The charter school can make referrals and do their own evaluations, but they don't necessarily have to, right? The CSC has to, and we'll talk about that a little later. The DOE has to. Um, but the charter schools must provide all the information necessary as it relates to any of the pre referral interventions that they've done thus far, such as RTI. Okay, next slide, please. So, understanding who is responsible, so to speak, for a student with an IEP in a charter school, we broke it down into two categories: what the DOE must do and what the charter school must do. The DOE must evaluate a student, determine their eligibility. They're the only ones who can revise and amend a student's IEP, and they're the only ones who can declassify a student. The charter school, on the other hand, they must provide the program and services to the student directly, right? That's one way they could do it. And that might look like hiring that professional outright, providing that service directly, or they can contract with an agency. We see this a lot for paraprofessionals, or they can ask the DOE to provide that service, right? So I like to think of it as the bucks kind of stops with the DOE through the CSE, right? When I say DOE for a student in a charter school, we're talking about the CSE, where that charter school is located. Um, so they're responsible for creating that IEP, and the charter school is responsible for carrying it out. Um, there's important things to note about this, though. Um, the process for a child and a parent should be seamless, right? So the charter school can provide services directly, right? They could hire um, both of their ICT teachers or any other service provider, but they're not required to try that and fail first. And that's important, right? So it is not a requirement that the charter school, for example, look for an ICT teacher, can't find one for 3 months, and then go to the DOE for assistance, right? They can go to the DOE at any time. This is not it. It's not a sequential thing, right? You must try this before that. So that's important to know. Your child's services should be provided. Um, and the nuance difference as to who does what is just important background for us to know when navigating and advocating, right? But in reality, it should feel seamless and the charter school should be supported if need be. Um, I think this is a good time to point out, though, that um, language and services could be referred to differently in a charter school. And one of the examples of that is ICT or an integrated co teaching classroom, right? Traditionally, that is meant to be a general education teacher and a special education teacher. Oftentimes, charter schools will say that they have an ICT program, but there isn't necessarily a general ed and a special education teacher. It could be two adults in the classroom. But if the child's IEP says ICT, there must be a general education and a special education teacher in the classroom. Um, this happens because charter schools have exemptions around certification criteria, and a certain number of teachers can be uncertified in a charter school setting without getting into the weeds of that. Um, Knowing what is meant by different programs and services and asking is often helpful. Sometimes parents will be unaware that their child doesn't necessarily have a special education teacher in the classroom, or the special education teacher that's in that charter school classroom isn't actually certified in special education per se or have a master's degree in special education. And so it's important to be aware of those things and ask if that is something that your child needs. Okay, next slide, please. So, as it relates to promotion criteria and students with IEPs, as we know, students with IEPs generally may have different promotion criteria, but there are processes or safeguards in place, and charter schools are no different. So, charter schools may use their own promotion criteria for students with IEPs. That's the baseline, right? However, charter schools may request modified promotion criteria for students with IEPs. Um, and this can be done either by the parent or the charter school, meaning the request can be made by either parties. Um, but before that happens, or during an IEP meeting, there must be a discussion or proof of the school's promotion policy, the proposed modification, and a rationale for that modification. So not just I think that this student is not going to do well on the exam and we would like to demote, but what is the policy, why are we doing it, and what is the proposed modification. um, this is similar to, but not the same as a mid-year demotion, um, which charter schools are allowed to do. However, there must be a meeting first. And so we'll talk a little bit more about that if we can go to the next slide. So we commonly see mid-year demotions or demotions for students in charter schools. And for students with IEPs, there must be a meeting, right? So the demotion, right, is a change of placement for a student with an IEP. And so the charter school must meet with the parent before demoting the student with the IEP. I will say the caveat to that is this is a very informal meeting. Right, and so sometimes it's done at an IEP meeting, sometimes there's a separate meeting convened, sometimes it's Zoom, sometimes it's a phone call, um, but it's an opportunity for the school to explain their rationale, for the parent to give their input and feedback. But if this meeting occurs, right, meeting occurs, then ultimately the charter school can demote the child over the parent's objection. This is very important to note, right? A lot of families do not realize that this is what they're consenting to when they enroll their child in a charter school. But if this meeting is held and the parent has an opportunity to express their um, opinion on what should be done, the charter school ultimately has the say. And so this may look like a child, for example, who was promoted to the third grade. They've been in the program for a couple of months, and now the school feels like they need to be demoted back to second grade for whatever reason. And after this meeting takes place, that child can indeed be demoted and start second grade the next day. Um, Now, every family in New York City has the right to go to a family welcome center and enroll their student in a DOE school or a district school at any time, right? And this is important to note because the district school or the DOE, um, they may have different criteria or understanding for promoting a student. So they may promote a student in a in a who's coming from a charter school setting, even if the charter school won't. But it's important to note that that is discretionary, right? So it does not mean just because your child was demoted in a charter school setting, that if you go enroll them in a DOE setting, they will place them in the grade that they were in. But it also doesn't mean that your child is quote unquote stuck in the grade they were demoted to. It really depends. And this is an opportunity where you want to go to the district, whether through CSE or the Family Welcome Center. And if this is a student with an IEP, this is a great moment to really talk about the supports and what is happening, why there was even a need for that, if there are any concerns. So, next slide, please. We spoke about students with IEPs, and so I wanted to also speak about students who have 504s in charter schools. So, as we know, we said that charter schools are public schools. Charter schools receive federal funding and are required to follow Section 504 of the Rehabilitation Act. This means that charter schools cannot discriminate against students with disabilities, and charter schools must provide reasonable accommodations to students with disabilities. Excuse me. Section 504 also has similar provisions to the IDEA, such as a free and appropriate education requirement or FAPE requirement. They must provide reasonable accommodations, as I mentioned a little bit ago. And they also have students with 504s also have certain protections and safeguards under as it relates to suspensions and expulsions. And we'll get into that a little bit more. Next slide, please. So requesting a 504 plan looks very similar in a charter school setting as it does in a DOE district school. The difference is for students with IEPs, this is done through the DOE, through the CSE. But students who have 504 plans, their plans are developed at the school level, so at the charter school, right? Charter schools should inform parents of students' rights to 504 accommodations, and parents can request a 504 plan from the charter school at any time. Similarly to students in district schools, um, parents um, parents or doctors should be very specific about the types of accommodations that they're requesting, right? This could be classroom accommodations, breaks, testing accommodations, physical modifications, etc. Next slide, please. Okay, so I know that I kind of breezed through students with disabilities in charter schools, but we talked a little bit about IEPs and Section 504s. Um, uh, Advocates for Children has a lot of resources on our website. So we encourage everyone who has further questions. We have a lot of guidance and fact sheets. So if you do have any of those questions, feel free to go to our website or to hover your mouse over this QR code or call our helpline, as I mentioned earlier, because, of course, there's a lot to students with disabilities in charter schools, and we just began to scratch the surface today. Next slide, please. So, the other area that we see a lot here at Advocates for Children as it relates to charter schools, or what I think makes um, my practice area here unique, is the world of school discipline in charter schools. So, I want to talk about students' rights and protections, and also highlight the rights and protections of students with disabilities. Um, so, next slide, please. So, I have another true false. True or false? Charter schools in New York City must follow the DOE's discipline code. What do we think? True or false? Again, feel free to put your I hear false in the chat box. Anybody else? False. False. Okay. You are all absolutely correct. Um, Charter schools do not have to follow the DOE's discipline code. Um, I'll get into this later, but the only exception is if they say in their handbook that they follow the DOE's discipline code. Then they must follow the DOE's discipline code because they must follow their own codes. But for the most part, the rule of thumb is that charter schools do not have to follow the DOE's discipline code. Next slide, please. So we'll dive a little deeper. Why is that? So, discipline in charter schools, how are they different and how are they similar? So, discipline in charter schools is different in that charter schools create their own discipline policies. They are allowed to create their own discipline policies. And the DOE's discipline policy, as you all have pointed out, does not apply. How they are similar is that charter schools, although they create their own discipline policies, they must follow federal due process rules, right? And state and federal special education law. I will say that I often think in our great state of New York and in New York City, oftentimes federal laws are the floor and not the ceiling for us, meaning a lot of times our local rules and regulations is what brings in the detail in the color, right? Provides greater protections. Um, Sometimes way before federal laws and regulations catch on or before other states catch on. And so what we see is this great difference between charter school and kind of their discipline policies and codes, because yes, they're following the federal laws, but some of the protections that we come to expect in New York City really come from our local, right? Our DOE discipline codes, which do not apply in a charter school setting. So I often encourage families to look at that prior to enrolling. And I know many families who want to enroll are often surprised at what the charter school's discipline code may contain or the minimal protections that are afforded. Next slide, please. With that being said, let's look at what is a lawful suspension in a charter school, right? Charter schools must follow their discipline code. That sounds like a no brainer. I cannot tell you, though, how many times that is not the case. So, if an incident arises, families, advocates, etc., even schools, the first thing they should do is turn to their own discipline code, right? And make sure that their discipline code, at the very least, is followed, right? And this applies to in school suspensions, out of school suspensions, expulsions, or even informal removals, right? Next slide, please. So, what is an illegal removal, right? Well, couple right off the bat is suspensions for undefined periods of time. Again, this sounds like a no brainer, but sometimes happens, right? And should not happen, right? A call that says your child needs to be picked up, and the parent's like, I don't know for how long, what happened, right? So, any suspension for an undefined amount of time, automatic triggers, those are improper, right? So, if you um, do this thing, right? So you violate our attendance policy, or you don't wear the right uniform, or whatever, 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 right? That automatically results in a suspension. Well, that's improper, right? Conditional returns after suspension. So you must have this meeting, you must sign this document, right? There are very few exceptions to this rule. Um, and then shortened schedules. So the idea that a shortened school day or an informal removal from class um, doesn't count is not proper, right? It is considered a removal, and so it must comply with federal due process rights as well as federal and state special education um, requirements. Also, double jeopardy does is improper, right? Now, this is a little nuanced, right? But generally, the idea that a student can be um, punished or there could be consequences for the same act more than once is improper. However, um, in the consequence phase, for lack of better words, right? So, not in the fact finding phase, not to determine whether the child actually did what the school is alleging, right? They hit, they whatever, right? Not in that phase can prior acts be used. However, in the consequence phase, prior acts can be brought in to determine what the proper consequence is. So that's where it gets a little tricky. But generally, as we know double jeopardy to mean commonly, right, being punished for the same thing twice, that is improper. Next slide, please. Okay. So, one of the most basic due process rights that we often see as a challenge for families in charter schools is notice. So, we're going to talk about what is required in terms of notice. So, parents have a right to notice of the charges and the basis of the allegation, right? So, not your child is misbehaving and needs to be taken home. There was an incident today, needs to be taken home. No, right? Notice of the charges and the basis of the allegations. They're also entitled to notice before the suspension unless the student possesses a continuing danger or ongoing threat of, of disruption to the school community, right? Um, if that occurs, then the school can ask for the parent to come and pick up the child. However, there is still the obligation that the notice must be made as soon as possible thereafter the suspension. If regardless, and if the immediate removal is allowed, then they must still give notice. And we get this from case law called Scott v. Lopez, which gives us a little bit more clarity that oral notice on its own is not sufficient. So schools can make that initial call to tell you what happened, or in this example of the exceptions, ask for the child to be picked up. That can happen, but it must then be followed by written notice, right? And that must be done within 24 hours. Um, or as soon thereafter, which has been interpreted to mean within 24 hours. So notice is a very important thing. Oftentimes, the first thing that you should look for is where what was the suspension letter, right? Suspension notice, suspension letter, something that notifies you of the charges and the basis of those allegations. Next slide, please. Okay. So the right to be heard. Um, parent Parents and students have a right to be heard in both short-term suspensions or removals and in long-term suspensions and removals. They look different depending on which type of a removal we're talking about. So we're going to talk about short-term removals first. In that instance, students have a right to explanation of the evidence and a chance to tell their side of the story before they're suspended, unless, again, these are the exceptions, a continuing danger to people or property or an ongoing threat of disruption to the academic process. It doesn't mean that they then don't have a chance to be heard. It's just the immediacy of that and how that's communicated, right? However, the big caveat here is students cannot be forced to give a statement against their own interests, right? So the idea of self-incrimination happens in this realm too. It's important. It's really, really important to keep that in mind because things that are happening in the school context have um, or can have um, consequences in other realms, right? So when does that come in? Off the top of my head, I can think of an example as some type of physical altercation, right? In the school discipline context, we may be thinking, "Oh, this is a school matter." Yeah, but it could also be a criminal matter, right? And so the idea that you would incriminate yourself because the things that are said during this process are open, they're free game, right? It's not like a closed universe or a closed case. So it's important to keep that in mind. Next slide, please. So for longer term suspensions, and I'm using long and short term suspensions, and it's important to keep in mind that we would look to the school's code of conduct to determine what do they consider short and long term. We know that long-term suspensions, as laid out in Gosby Lopez, is absolutely 11 days or more, regardless of what it says in the code of conduct. But it could be shorter than that. A school can determine that 6 days or more is considered a long-term suspension. And if so, the rules that apply to long-term suspensions would apply in that case. So for what we consider to be long-term suspensions, there are more formal due process protections and procedures. So, first, the charter school must provide a chance for the student to be heard. How we do that um, is through a disciplinary hearing, right? The hearing in a long term suspension. The hearing officer must be impartial and base their decision on evidence presented at the hearing. So I just want to pause there because I think that this is an area that can often be challenging for families and even schools, right? Because what it means to be impartial, um, depending on who you ask, I think that's very gray, right? Um, what we know is that impartial means that they're unaware of the incident that has occurred, right? And that they are vowing to make their decision based on the evidence presented. However, that could mean that it is a member of the school community, meaning a teacher or faculty member or administration, maybe your child is in middle school and they're coming from their high school campus or their elementary school campus. So yes, they don't know the incident, but they're not necessarily an outside entity. That's very important to keep in mind. I have had instances where the impartial hearing officer was on the board of trustees of the charter school, right? And without getting into too much detail, I think there's questions there about true impartiality, right? There's information you inherently know because you are part of that school community. Um, and I'll leave it there. Okay. So there's a hearing officer, and the parent has the right to call witnesses, to submit evidence, and to be represented by counsel. This is a big one. Um, if you don't have counsel, if a parent doesn't have counsel, they can request for the hearing to be adjourned until they can find counsel. Um, and the hearing must be recorded. This is important because it can't be someone taking notes, right? It's a recording. Um, and this is a little easier today because oftentimes these are done on some type of Zoom or team platform, and you're able to record that way. Um, I will say that in the long-term suspension process, it is more formal because you have this disciplinary hearing. The opportunity to be heard in a short-term suspension context, that is a little grayer, right? The chance to be heard, it could be a meeting, it could be a phone call, right? The parent could have this exchange with the principal, or the child. So it is very different in a short-term context. Oftentimes, families will be unsure, right? Like that didn't feel formal. But in a long-term suspension context, it is very clear, right? You have a right to a hearing. Next slide, please. Now, if a parent or guardian is are not satisfied by the outcome of a hearing, or has a grievance with a charter school. Um, and this is really for a wide variety of reasons, but school discipline being one of them. Um, and it is common not just because they don't get the outcome they want, right? But because charter schools have the discretion to create their own discipline policies, I think it's important for families to be aware of them, to ask for them, to read them, because there are things that may be surprising to you, right? Like talking back to a teacher, that could result in a suspension. Rolling your eyes can result in a suspension. Not wearing the proper uniform can result in after school detention. And sometimes parents are just unaware of that, right? They may think, well, these are common issues that are developmentally common, and I didn't think that we would be here at a suspension. So, even though charter schools are within their right to have that, sometimes if for whatever reason the parent is dissatisfied with the outcome of a hearing, or their due process rights for some reason weren't followed, they can follow the charter school's grievance process, which is appeal to the charter school's board of trustees. That's the first thing. If you're still unsatisfied with their decision, a guardian or parent can appeal to the charter school's authorizer. And if you're still dissatisfied with the answer, you can appeal to the Board of Regents. Now, I cannot stress this fact enough. There is absolutely no timeline or requirement in terms of time of response from any of these levels of review. This can often be very frustrating for families because obviously, I like I say all the time, our real lives are happening every day, right? Whatever's occurred is crucial, right, to your child right now. Um, and with the structure that currently exists, without, going through the legislator, there's no timeline for which any of these levels of review has to respond to the parent. If the Board of Trustees meets twice a year, a parent may be waiting until the next Board of Trustee meeting, right? Or an authorizer could take 2 years to respond to a parent. that doesn't necessarily help the immediate situation. And so it's important to know that up front. Okay. Next slide, please. So we talked about what charter schools are allowed to do and not allowed to do generally. I want to just point out the safeguards that are specific to students with disabilities in charter schools. Again, we talked about IEPs and Section 504s and who covers what. Similarly, in a discipline context, we have the CSC's responsibility for students with IEPs and the charter school's responsibility for students with 504s. Both students with IEPs and 504s are entitled to MDRs, right? The CSC must hold a manifestation determination review or MDR meeting for a student with an IEP, and they must conduct any evaluations that are necessary. Uh, on the other hand, charter schools are responsible for holding the MDR for students with 504 plans. And we'll talk a little bit about what an IEP, what an MDR meeting looks like, but it's important to keep in mind this is for students with IEPs and Section 504s or students who the school or the DOE is deemed to know has a disability. They're also protected under this MDR requirement for longer suspensions. So next slide, please. Okay. So what is an MDR? An MDR is a meeting to decide if the student's behavior was either one, caused by the student's disability, or two, cause or result of, or two, a result of the school's failure to implement an IEP or a BIP or a 504, right? So either one of those, you're looking at both. It's you don't have to arrive at the conclusion that both happened. If one of these two things happened, then it would be a manifestation, but we'll get into that. When are MDRs required? They're required for students who are suspended 11 or more days within 40 school days, or if there's a pattern of behavior, right, for which the child is being suspended. An MDR must be conducted. An MDR meeting is informal. It feels a lot like an IEP meeting for families who are used to those. The parent is present. The student may or may not be present. That is a decision of the parent, but they have a right to be if the parent thinks that that's appropriate. An interpreter, if that is needed, and anyone who is knowledgeable or an expert about the child. Oftentimes, that may be outside providers or evaluators who are working with the student, and any relevant school staff as well. Next slide, please. So, is it a manifestation? If it's a manifestation, meaning that the behavior or the incident was caused by a result of the student's disability, or that the student wasn't receiving their IEP, their BIP, or their 504 plan, then yes, it was a manifestation of the child's disability, and the student must return to school, right? The CSC then has the responsibility, if it's a student with an IEP, to provide any FBAs or BIP as necessary, or any expedited evaluations. If it is not a manifestation, then suspension continues as it would for a student without a disability. The CSC must consider doing an FBA and BIP, however, right? Because there may have been something there, right? And determine placement and services during the suspension. And this is important because students with disabilities are entitled to services to continue to participate in their educational curriculum. And the CSC, if the student is found it's not found to be a manifestation, has to work with the school to determine what that looks like. Next slide, please. Okay. So that was school discipline. I know we covered a lot of areas, and just to kind of recap them, um, mid mid-year demotions are improper without a meeting. We talked about how informal that meeting was, and that charter schools ultimately have the final decision making there, but that a meeting must occur. Students suspended from charter schools have due process rights and a right to alternative instruction. Whether it is a manifestation or not, they're entitled to alternative instruction while on suspension. Um, Make sure families and advocates should make sure that students with IEPs get MDRs when suspended. And another huge takeaway is that charter schools must follow their own discipline policies at the very least, and must also follow federal rules and state education and special education rules as well. Okay, next slide. So I want to take this opportunity to put the survey up for this particular training. As I open the floor for questions, I am dyslexic, so I am going to ask Kim to look at our um, chat box to see if there are any questions that I haven't covered that we can address during this time. It looks like Kim has also put the feedback survey up on your screen. So if that is easier than the QR code, you can do that as well.
Yeah, thank you so much for taking the surveys, and I'll post a couple other ones as we go through the questions. I know there were some questions in the chat and some questions in the Q&R, so hopefully I don't miss it. If I do miss it, please put them in the I'm sorry, Q&A, not Q&R. Reading in the Q&R, one person asked with regards to discipline,
Mhm.
is it illegal to force students to make statements against their own interest? Our charter school requires a written confession statement before coming back from suspension. They call it a self-reflection, but the prompts are worded to explain what you did wrong.
So I hope that I was clear. I think this intersects with two things that came up in the PowerPoint. One is students have a right to not self-incriminate, meaning giving a statement against their own interests, right? I hit so and so, I'm sorry, right? Is an admission of that. Thus, it's improper. Also, what I'm hearing in that question is that this particular charter school requires a student to do something after coming back from suspension, i.e., signing this document or admitting to their wrong. That is also improper. It's a conditional return. The consequence or the punishment or whatever word you want to use to describe the result of the suspension, right? The suspension itself is the consequence. Full stop. Right? So requiring families to sign something or right before entering to have some kind of contract, that's improper. And so if a family is experiencing this, I encourage them. We have a reference guide on our website, but sometimes that is not enough. And if families need assistance, please feel free to reach out to our helpline. Um, so short answer, no, that's very improper.
And I apologize. Thank you to the 10 people who took the survey. You don't have to take it again, but I just realized we had 2 survey polls. This one allows you to answer some things in free form, and we really do read these a lot about what you learned, what was helpful, and also especially if there's more that you would like to have trainings on. So going to the some more of the questions, Patara, there was someone who asked, is there a good written document we can reference to describe the illegality of conditional suspensions?
We have a discipline guide here at AFC. Um, I often refer to commissioners' decisions, who have laid that out. I believe that the Federal Department of Education has some guidance on this as well. I don't have anything off the top of my head though.
And this is another question about discipline with if a parent calls a witness who
Mhm.
is another child, and the other child's parent doesn't want their child questioned, what happens?
So I think this is really important, right? The idea that this is a robust hearing. I think a lot of families, especially families whose students have IEPs or 504s, they may be thinking of the impartial hearing process or even the DOE hearing process. And for charter schools, um, there isn't a right to, for instance, subpoena witnesses, right? And so there isn't a right for parents to force another student to act as a witness or even a teacher or a principal. And I think that's important to note because there are many hard conversations I have to have with parents who, rightfully so, feel like they deserve their day in court. And the disciplinary hearing is not that. And so, if the case that you're mentioning, where the parent wants to call a student who was a witness to this and the other student's parent says no, then they cannot call them as their witness, unfortunately.
Um, Another discipline question. We have three more questions that I can see, although there may be some more in the chat. The child hasn't been suspended, but the school continuously requests for the parent to come pick the child up midday. Is it okay for the charter school to do this?
So no, those are that's a classic example of an informal removal. A removal, i.e., a change of placement, i.e., the child is not going to their regularly scheduled program, is a removal. And depending on how often this is done, right? A parent could be entitled to either, right? This is happening, and I've had clients for whom this was the case. It is heartbreaking, where it's every single day for months and months and months. Therefore, we're now talking about either the right to a hearing, depending on how long this is happening, how long they're out, or if this is just happening every day. So there's not like a length of time. They might not be entitled to a hearing, but they're most definitely entitled to an MDR, right? Why? Because A, it's more than 11 days out of the 40 some odd days needed, but also it's become a pattern in practice. So the parent should absolutely be asking for an MDR meeting.
Um, okay, another question is, does a student over 18 have additional rights regarding his or her IEP?
So I'm not certain about what that question is asking, but a student is entitled in New York under IDEA to have IEP services um, until they turn 22 now. And without getting into detail about what that means and the exact timing of that, it means that a student who is 18 has a right to still receive an IEP. However, the IDA right is a right held by the parent unless they are an emancipated minor. And so that is very tricky in the sense that, for instance, here at Advocates for Children, right, we represent the parent, right? Because in most cases, right, the parent is the legal guardian of that student, and therefore they hold the right to go to due process to make decisions on that child's IEP. As a practice, though, we try to listen to the child and the parent and make sure that their wants and needs are on the same page, and have certain internal safeguards in which we wouldn't necessarily act on or represent a parent who holds that right but isn't necessarily on the same page as the child. So I know that's a convoluted way to answer. Does the child have any particular rights? the oversimplified answer to that is no, right? Because the IDEA, right, is still most likely held in the parent, but they should be a part of that process, right? We shouldn't be making decisions about individuals. If, for instance, the student says, "I don't want to do that. I'm not going to do that. I'd rather do X," right? So I'll stop there, but I would say the short answer to that is probably no, and I apologize if I misunderstood the question.
Yeah, I think Patar and I both are guessing at what that question means. The only other interpretation I could think of is we do often see people who think that students can only go to high school until 18, but any student, regardless of whether or not they have an IEP, has a right to stay in school until they get a diploma or until they turn 21. And now I think it is 22, although there's a little bit of debate about how that will play out in
Yes.
reality. Um, okay, we may not get to all the questions, so we're going to try, but if we don't, certainly feel free to reach out to our helpline. Thank you to everyone who took the survey. If you can take the survey, it's really, really helpful. Um, Somebody asked, do you see a pattern of charters using aggressive suspension practices as a form of pushing a family out of the school? Is that something that is actionable in court if a family feels like that's what is happening?
Ooh, yes.
Well,
So
you
we
need a
can,
lot more details, right? Maybe.
um, yeah, maybe, but really the answer is probably not. And
Yeah.
why I say that is I don't think that families or advocates really understand the broad discretion that charter schools have, right? So if they are coloring within the lines, right? Meaning they have this code of conduct, you are not following this code of conduct, they are able to suspend, right? That doesn't necessarily mean that good is probably not the word, but that a good educator or school community would do so if they know that there are other things going on, but it doesn't mean it's improper if they do, right? And so we often see families who there are repeated suspensions, right? But they're following the rules. So they're suspending and then there's an MDR, then they're suspending and then there's an MDR. So there becomes this pattern that ultimately pushes the parent and the child out of the school. But the four corners of the law, the charter school isn't doing anything wrong, right? The CSE is involved. They're doing, they're doing the FBA. We're relooking at it. And so it's a very hard one. I often hear from a lot of my clients and colleagues who are like, this feels very uncomfortable. This feels very cringy. It doesn't feel like this should be able to happen. And the answer is both things can be true, that this could be very unfair or very cringy, but not illegal,
Yeah,
right?
speaking of cringy, someone else had a related question, and I feel like, oh, this is on either end. I definitely know the answer to the second part of this, but maybe not the first. Is a charter school allowed to hold a student all day in solitary isolation or suspend them for using a four-letter word? No violence, aggression, or fighting.
So no and yes, meaning no, you cannot lock a child in a room in isolation, right? Like we are there are a lot of things that are now coming into play, right? And other kind of due due process or federal protections, definitely change of placement. There's a whole bunch of things there. So the idea that you're in isolation, I also I'm hesitant because I don't exactly know what that means. If it means you're doing work in the library while you serve out your suspension, that is most likely not going to rise to the level of self isolation. That is improper, right? That doesn't mean that certain forms of punishment, rubber room, I don't know, other things that we know without getting into that, that can sound like it could borderline on something, especially the way that the question is phrased. But if it is in a room doing work by yourself in suspension, that is not improper. Um, the second half of that question, can you just
Oh
read?
yeah, the four-letter word. I mean, I think you
Oh,
already covered it, Patara,
yes,
with it. You can get suspended for rolling your eyes, so you
yes.
certainly could get suspended for using a four-letter word.
Absolutely,
Um,
and what I hear most from parents is, "I had no idea." I mean, this is absurd, and I had no idea, but you were agreeing to that when you enroll your child, and so it's important to realize that even though that may seem absurd to anyone else, that is the code of conduct you've agreed that your child would abide by. And if the conduct is a manifestation of their disability, meaning talking back, aggression, etc., they can have an MDR. That doesn't mean, though, it goes back to the question before, then what does this become? This becomes a cycle, or parents feel pushed out, or it's being used, right? Because eventually you're going to give up and say, this is toxic and we can't be here anymore, right? But if I'm just purely answering the question, absolutely. A child can be suspended for rolling their eyes, for swearing, for talking back to someone, for walking away from someone, for walking out of a classroom, walking into a classroom, making loud noises, et cetera, et cetera, et cetera. As long as it's within their code of conduct to punish that behavior, it could be done.
So I'm going to lump together the last two questions that I see because they're sort of related. It's two different people asking them. And just to sum up the two questions, one is basically it sounds like in addressing sort of the cringe factor that you were describing. What do you do if your leadership team has no interest in adjusting protocols to be in compliance with the law, or this is just how we do things? And the second question that I feel like is connected to, oh my goodness, what do we do if this is happening? Is there any kind of legislation that requires data to be reported to the state or the DOE about the flexibility with suspensions and promotion requirements? Although I think that unfortunately that's the whole idea with charters, is the flexibility. And from the questions coming in, I think many of us are uncomfortable with where that leaves some students and some families. But anyway, I don't know, Patar, if you have any thoughts on legislation, which is a global level, or thoughts on what to do, on a local level for somebody who works with a school that is doing stuff that seems questionable.
Ooh, those are both very, very loaded questions. And so I'm going to try to answer them as diplomatically as possible. Um, I don't have the best advice for someone who's on a school level. I think that, especially if it's a student who has an IEP or a Section 504, I think bringing and framing it as supports and services and what is happening. Also, I know, I get calls from school level administrators about things that are happening, and there's often opportunity. I think sometimes I've seen a lot of different ways that it can go, right? Sometimes schools are just unaware. That seems like a low cop out, but there are times when I've had school council who are able to step in, or school communities. Maybe it's, you don't have a very receptive principal, or based on your positionality, kind of don't feel comfortable teaming up with other people, talking about restorative justice. A lot of charter schools do have that language in their handbook, but they don't necessarily have anything in place to interpret what that means. So maybe talking about, okay, this is behavior we don't condone. What restorative practices or programs can we implement, and what would that look like? And really having creative solutions, unfortunately, because I guess the second half of that question is um, kind of the chicken or the egg, right? I think there's a bunch of things that are happening here without getting into the weeds. I think there's a debate around whether 3214 applies to charter schools, and whether it should apply. Some of this stuff that I'm saying is proper. I don't necessarily, at my core, feel like it should be. But really, until we're changing legislation and requiring that, right? Again, a lot of the color, as I call it, comes from local regulations. That's why the DOE's discipline process, looks a lot different than charter schools because of the local regulation. That doesn't exist at the charter school level. And I think that Kim is correct in that, that is kind of the pro or the allure to charter schools, is this broad discretion, but there is absolutely room for guidance, right? And I'm not saying this in an anti-charter, pro-charter world. I'm saying stepping out from that, I think that the clarity it would be helpful for both the school, right? To the educator's point in the first half of this question, what could I do? Having guidance from the school, but then also the parents. It would come from legislation, and there are some bills that are floating out there, and without naming any, but to answer the second part of that question, it doesn't exist. We have Goss v. Lopez. We have very broad um, minimum requirements of what this looks like. And that, my feeling is that there should be, and that there is room for deeper regulations and rules, and what that looks like. I know there is a lot of different opinions on what that looks like in the charter school advocacy, parent, whatever world. I think everybody comes from it from a different place, but I think the second half of the question alludes to the fact that maybe legislative and policy changes are needed here.
Great. And thank you so much to everybody that's answering the polls. I realized there were two more polls that we collect all of this information for our funders. And it's really, really helpful. We'd like to know who we're training and how the training went. So I just have one more for about students with IEPs. And then it looks like Eileen asked to talk. So I'm going to try to figure out, hold on if I can figure out how to stop the recording.